Hi, and welcome to this week's episode of the Case of the Week series brought to you by eDiscovery Assistant in partnership with ACEDS. My name is Kelly Twigger. I am the CEO and founder of eDiscovery Assistant, your GPS for eDiscovery knowledge and education. Thank you so much for joining me today. A couple of announcements before we get started. I'm working with the Midwest chapters of ACEDS on a 4-part webinar series on ESI protocols. There are 4 webinars in total. The first 2 have already aired but are available to stream at the link that Deja will add for you in the comments. The third installment will be a judges panel moderated by my good friend David Horrigan on June 6th. And I'll be hosting a workshop on ESI protocols in July. You can use the link to sign up to receive more details and view the previous sessions. Next week, our team from eDiscovery Assistant will be in Chicago at the Masters Conference at Seaforth Shaw. And we'll be conducting a breakout session in which we invite you to play our eDiscovery Navigator trivia game. Come and test your knowledge of all things eDiscovery. If you're in the area or planning to attend the Masters, add our session to your agenda. If you'd like a free pass and you're in-house or at a law firm, you can email us at support@ediscoveryassistant.com and we'll get you set up there. Now on with our show. Each week on the Case of the Week, I choose a recent decision in eDiscovery and talk about the practical applications of that case. This week's decision hits on the important topic of general objections. Despite the rule changes going back to 2015, we are continuing to see multiple decisions on this issue, with 56 cases already addressing it since January 1st, 2024. As we'll see with this decision, courts really have no tolerance for vague objections that do not provide the specificity required by the Federal Rules of Civil Procedure as of the amendments in 2015. Let's dive into this week's case, which comes to us from Byte Federal, Inc. versus Lux Vending, LLC. This is a decision from United States Magistrate Judge Sean Flynn from the Middle District of Florida, dated May 1, 2024. Judge Flynn has 38 decisions in our eDiscovery Assistant database, so he is no stranger to eDiscovery issues and tackles them with a lot of vigor. All right, as always, we assign issues to each one of the decisions in our database, and this week's issues include failure to produce, cost recovery, general objections, cost shifting, competency of counsel, privilege log, proportionality, social media, text messages, bad faith, third-party subpoena, Slack, instant messaging, and cloud computing. Now, that's a lot of issues, but mostly the analysis from the court focuses here on the general objections. Many of those issue tags are related to the sources of data that are at issue for the request for production that have not been responded to, or documents produced in response to, I should say. All right, what are the facts before us here? We are before the court on a motion to compel in a trademark infringement dispute. The plaintiffs here initially sent a subpoena to the Cardamon Group in May 2023, and then added the Cardamon Group as a party in August 2023, alleging that they participated in the infringement through their provision of advertising and marketing services. Now let's take a look at the timeline, and that's one of our crucial themes here on Case of the Week, that it's one of the most important tools we have in analyzing eDiscovery issues. Plaintiff initially served the third-party subpoena on the Cardamon Group on May 26, 2023, and requested production of materials responsive to the subpoena by June 8th. Cardamon hired counsel on June 5th, just 3 days before a response was due, and counsel requested an extension, which plaintiff granted until June 16th. Of note is that the 16th was 4 days before a scheduled mediation in the matter, and plaintiff wanted a few days to review the documents. But Cardamon did not respond by the deadline and instead filed a motion to quash on June 12, 2023, arguing that the subpoena sought confidential information and was unduly burdensome. While that motion was pending, plaintiff added Cardamon Group as a party in August and served their first set of requests for production on Cardamon on September 21st, 2023. Cardamon served its responses and objections to the first set of requests for productions on October 23rd, 2023, but did not produce documents with its response or provide a date on which it would produce documents. The court then denied Cardamon's motion to quash the subpoena on October 26, 2023, and compelled Cardamon to respond to the subpoena. On November 7th, 2023, plaintiffs filed this motion to compel, seeking production of documents in response to the subpoena, to have the court overrule Cardamon's objections to the first request for production, and to compel Cardamon to immediately produce all documents responsive to the first RFP. I'm going to refer to Cardamon now as defendant, just to make it a little bit easier in understanding parties. The defendant then produced some documents on November 9th, 2023, leaving objections to 9 requests for productions at issue, as well as the plaintiff's request for attorney's fees on the motion to compel. So that's what we're before the court here, are those existing 9 requests for production that the defendant objected to. So the court begins its analysis with the language of Rule 26, that discovery must be relevant, non-privileged, and proportional, and that the party moving to compel carries the burden to show that the discovery sought is relevant. The court then waded into the individual requests and the objections at issue. Request number 7 from plaintiffs sought ESI from 3 corporate email accounts at defendants, responsive to a Boolean search query that plaintiffs provided as part of the request. So a specific search query that plaintiffs put in their request for production, asking for documents responsive to that query for 3 specific corporate email accounts. The defendant objected, stating, quote, on the basis that it is vague and incomprehensible as written. For this reason, Cardamon is not providing any documents responsive to this request unless and until it can be clarified, close quote. The court overruled a defendant's objection, finding that it did not explain how the request was vague or what defendant failed to comprehend about the request. Now that one seems pretty obvious to me. The court also dismissed production issues related to the client's lack of knowledge of e-discovery, finding that, quote, while Cardamon's client may be unfamiliar with electronic discovery practices, it is its counsel's responsibility to assist with this process, close quote. In doing so, the court cited to EEOC versus M1 5100, the case that we covered on our first episode of Case of the Week back in 2020, which held that, quote, the relevant rules and case law establish that an attorney has a duty and an obligation to have knowledge of, supervise, or counsel the client's discovery, search, collection, and production, close quote. The court next turned to request number 8 and 9 sought by the plaintiffs, which pertained to the traffic by visitors to a website, www.bitcoindepot.com, including impressions, clicks, and hits. The request also stated that it should include traffic by visitors within the state of Florida. The defendant objected, stating that the request was, quote, vague and incomprehensible, close quote. The court again dismissed the defendant's objection as boilerplate and found that, quote, a fair reading of the request shows that Cardamon wanted documents showing how much traffic Bitcoin Depot's website received each month and year while it was a client of Cardamon. If Cardamon did not track website traffic in that manner, it should have stated as such in its response, close quote. The court then turned to the next objection, which was for request 11. That request sought ESI pertaining to invoices, statements, payments, wire transfers, credit card receipts or transactions, and other financial records exchanged between the parties. The defendant objected to the request as overbroad and not proportional, but provided no specifics as to why. The court again dismissed the objection as boilerplate. Then the next request, for request 13, sought ESI pertaining to online advertising, social media advertising, or keyword advertising, including without limitation, Google-sponsored ads or Google AdWords. Cardamon again objected to the request as vague and not proportional, but only offered a further explanation in its brief in response to the motion, then claiming that, quote, there are likely thousands of emails, texts, and Slack messages potentially responsive to this request, but which have no relevance to the issues in this case. Searching through all these messages and reviewing them for which would be relevant would take one or both of Cardamon's 2 employees many days of research and would substantially impair Cardamon's ability to meet its day-to-day business obligations, close quote. Just going to leave that there. Seems like an odd response to a company who is at issue in litigation. The court rejected Cardamone's objection as boilerplate and found that the topics requested, quote, bear directly on the trademark and false advertising claims at issue in the lawsuit, where plaintiff alleges that defendants conspired to use plaintiff's trademark in digital advertisements. Moreover, participating in discovery is often, by its very nature, burdensome. The suggestion that there are likely thousands of documents that may take, quote, many days to review is insufficient for Cardamone to meet its burden as the objecting party, close quote. The plaintiffs also sought costs for the motion on both the subpoena response and the first set of requests for production. The court denied the motion as to the subpoena, finding that Cardamone produced documents in a timely fashion, but did grant the motion for costs on the first RFP under Federal Rule of Civil Procedure 37A5A, finding that Cardamone's use of boilerplate objections were not substantially justified and its unpersuasive post hoc justifications for its boilerplate objections were not persuasive. The court then ordered Cardamone to produce documents consistent with its order within 14 days. So essentially, Cardamone comes to the court with very little on a basis for objections, and the court denies all of its objections. So overrules all of them and grants in favor of the plaintiffs on the motion to compel. What are our takeaways here? Well, in essence, there was no need for this motion. We've talked about this multiple times on the case of the week, but remember on last week's episode when I applauded the efforts of counsel who worked together meaningfully to create an excellent outcome? Not so here. Counsel for Cardamone here was the opposite of cooperative and sophisticated, and they paid for it in having to cover the costs of a motion. The result here is just delay in the matter and additional costs for the client. The client will now pay for them to redo their discovery responses, incur all the costs to comply with them, and pay for the costs of plaintiff's motion. I'm really just not seeing the upside of the conduct giving rise to this motion. More, it really implies that we've got inexperienced counsel who don't understand the evolution of e-discovery case law over the last 10 years. The amendments to Federal Rule 34 in 2015 changed the language of the rule to require specific objections to each discovery request. It not only eliminated the blanket list of general objections that most parties include prior to the individual responses, but required that an objection to an individual discovery request, quote, explain its reasoning in a very specific and particularized way, close quote, relevant to what the request seeks. If you are still using general objections, or if you are not stating specifically why you object to a request and how it bears on the relevance or proportionality of the facts of the case, you're going to have your objection overruled. Read this decision as well as a long line of cases starting with Fisher v. Forrest from 2017. You can use the issue tag general objections within eDiscovery Assistant to be able to highlight those cases. Now, the types of data sought here to prove plaintiff's case are becoming increasingly common, and counsel need to start understanding what exists and where they need to go to get it. We're talking about a lot of the advertising and marketing tracking data. We are completely immersed in an online world now. We shop online, we order cars via an app, we do banking online, we socialize online, and every single activity of that work is tracked. Whether for marketing or sales or to build your own following, all of the steps that we take online are recorded somewhere. What you watch, how long you spend on it, what you pause over on your feed, what you click, it's all tracked. Web traffic is vital to selling products online. It is only reasonable to acknowledge that data is being tracked, will be relevant to infringement litigation like this matter, and it will have to be provided. So learn what data exists, where it lives, how to go and get it, and what your client's practices are so it can be provided on motions like this one, and these motions can be avoided. Now, counsel have obligations under the federal rules, and those obligations do not change or become relaxed when they have a client that is not educated on electronic discovery. Instead, it is incumbent on counsel, as cited in the M150-100 case, to assist the client in meeting those obligations. Cardamone here attempted to leverage its client's lack of experience with e-discovery as an excuse for its failure to comply, and the court was having none of it. That's not going to fly. We've had these rules for more than 9 years, and the original amendments for almost 18 years. It's time to get on the train, or it's going to leave without you. At this point, you need to be in a full out sprint to catch it before it leaves the station. All right, that's our case of the week for this week. Thanks so much for joining me. We'll be back again next week with another decision from our eDiscovery Assistant database. As always, if you have suggestions for a case to be covered on the case of the week, please drop me a line. If you'd like to receive the case of the week delivered to your inbox via our weekly newsletter, you can sign up at ediscoveryassistant.com/blog. If you're interested in doing a free trial of our case law and resource database, please jump to ediscoveryassistant.com to get started. Have a great week.